Hello, welcome to our channel. Today, we will be discussing another mode of extinguishment of obligations, that is compensation. Medyo may kahabaan din ito, so at least simulan na natin kaagad. Anyway, this is Article 1278 to Article 1290. Before I forget, para sa hindi pa nakaka-subscribe, please subscribe and click that notification bell para ma-notify rin kayo sa mga new uploads namin if in case. And if you find this video helpful, palike na rin. If you want to, you can share it to your friends too. If you have any concern, feel free to comment down below. Okay? So, simulan na natin Article 1278. Compensation shall take place when two persons in their own right are creditors and debtors of each other. Okay, so obviously this talks about compensation. So what is compensation? Compensation, accordingly, is the extinguishment to the concurrent amount of the debts of two persons who, in their own right, are reciprocally principal debtors and creditors of each other. Okay, pag yung dalawang parties ay naging debtor and creditor ng bawat isa. Note ha, to the concurrent amount of debts. When you say concurrent amount, it means that if yung isang debt is mas malaki kaysa sa isa, then the balance shall subsist. So meaning, compensation could be complete or could also be partial lang. And these two debts are extinguished without actual transfer of money between the parties. It takes place by operation of law. Okay? Now, example. Pogi owes Ganda the amount of 1,000 pesos. And in another transaction, Ganda owes Pogi the amount of 700 pesos. So, both debts, assuming that both debts are due and payable today. So, here, the compensation takes place immediately by operation of law, and it takes place partially. That is, to the concurrent amount lang ng 700 pesos. Dahil nagkaroon na ng compensation. So, Pogi shall be liable to Ganda for only 300 pesos na lang. Yung balance na lang. Kasi if the two debts, had it been that yung two debts ay same amount, then there is a total compensation. So, yun nga. Okay, dahil 700 lang, tapos yung isa ay 1,000, nagkaroon ng compensation as to the 700,000 na amount. So, yung maliit na, smaller amount is totally extinguished. Pero yung larger amount, magkakaroon ng, remaining balance, that is 300 pesos. So, yung 300 pesos ay magsasubsist, and so si Pogi shall still be liable to Ganda for 300 pesos pa rin. Okay? So, malinaw naman ata. Anyway, ito, don't confuse this or don't confuse compensation from confusion or merger. Sa confusion, there is only one person, diba? There is only one person and actually one obligation. In the same obligation, si one person ay naging isang debtor and creditor ng sarili niya, kaya na-extinguish, di ba? Kasi parang yun nga absurd, babayaran mo yung sarili mo. And eto naman si compensation, meron siyang dalawang parties. Pero yung dalawang parties ay naging debtor and creditor of each other. Okay? Kasi meron ding dalawang obligation. So, iba sila ni confusion. Yun yung pinagkaiba nila. Okay? Now, let us also, distinguish this from payment. Ito. Si payment, it takes effect by act of the parties. Whereas si compensation, it takes effect by operation of law. Diba? Automatic siya. Granting na lahat ng requisites para sa valid compensation ay present, then magkakaroon na ng compensation by operation of law. Now, another is yung sa payment, parties must have the free disposal of the thing due and the capacity to alienate. requirements yan sa payment. Pero sa compensation, it is not required na meron talagang capacity to give or to receive as the case may be. Ang importante lang dito is present yung lahat ng requisites or ng requirements for a valid compensation, then magkakaroon na nga siya ng compensation by operation of law. And then, yung sa payment, another na pinagkaiba nila is, sa payment, it is necessary that it be complete. Pag hindi complete, pwede mong tanggihan. Pwedeng tanggihan ni creditor. Although, meron namang mga exceptions, which is na-discuss na rin naman natin previously. Sa compensation, it is allowed. Pwede talaga siya. The law permits partial extinguishment of the obligation. Kagaya nga nung example natin kanina, yung 700 tsaka 1,000 debts na nag-compensate, nagkaroon ng remaining balance na 300 pesos. So, which is, yun na lang yung babayaran ni Pogi. Right? Anyway, discuss na rin natin before we discussed in details yung mga specific provisions ng with regard to compensation. So, i-discuss natin yung kinds of compensation. Anyway, kinds of compensation is classified by its effect or its extent, and then according also to its cause or origin. Accordingly sa it is classified as to its effect or extent. Pwede siyang total, pwede siyang partial. Obviously, total when both obligations are of the same amount and are so, dahil same amount sila, entirely extinguished siya pag nagkaroon ng partial, pag hindi pareho. Mai-extinguish lang yung maliit na amount, pero yung mas malaking amount, magkakaroon ng remaining balance. So, partial lang. As to that one obligation na natira. Okay? Tapos, dito naman sa by its origin or cost, pwede siyang legal, pwede siyang conventional or voluntary, pwede rin siyang judicial. And last is yung facultative. When you say legal, then obviously, ito yung dinidiscuss natin. When it takes place by operation of law, pag yung lahat ng requirements are present. Voluntary naman, obviously, when it takes place by agreement of the parties. Then, judicial, when it takes place by order from a court. Tapos, facultative, when it can be set up only by one of the parties. Okay? Usually, pag facultative, ito yung hindi lahat ng requisites of a legal compensation are present. And so, parang naging siya sa isang party na pwede niyang i-compensate or hindi. Ganon. Now, let's take an example. Si Pogi owes Ganda 1 million pesos, demandable and due on, say, December 15 or 2020. Tapos, in another transaction, si Ganda ay may utang rin kay Pogi na 1 million pesos, which is demandable on or before December 30, 2020. So, comes December 15, 2020, si Ganda, who is given the benefit of a term. Kasi, yung sa kanya, yung utang niya is, di ba, payable on or before December 30, 2020. So, pwede siyang mag-claim ng compensation because actually, she can choose to pay her debt on the said date, on or before naman. Pero, si Pogi, he cannot claim compensation. Why? Because he cannot, force the Ganda to pay on December 15 kasi hindi pa naman due and demandable yung utang ni Ganda at that time. Although, on the part of Ganda, pwede na. Pwede niya nang mag-claim ng compensation. Okay? Now, just to make clear, iba siya kay voluntary kasi si facultative compensation is unilateral, kumbaga isang parties lang. When you say voluntary, doon sa voluntary nilang kinompensate, that is mutual consent. Silang dalawa mismo nag-agree. Dito, nasa kay Ganda lang kasi yung choice, so unilateral. And so, in that case, that is an example of a facultative compensation. Now, medyo mahaba pa ito. Wag na tayo magtagal. Let's proceed to Article 1279. Okay. Eto. Article 1279. In order that compensation may be proper, it is necessary 1. that each of the obligors be bound principally, and that he be at the same time a principal creditor of the other. 2. That both debts consist in a sum of money, or if the things due are consumable, they be of the same kind and also of the same quality, if the latter has been stated. 3. That the two debts be due. And 4. That they be liquidated and demandable. And 5th, that over neither of them there be any retention or controversy, commenced by third persons and communicated in due time to the debtor. Okay, obviously, this provision talks about the requisites of a legal compensation. If there is one provision about compensation na gusto ko ma-master ninyo at ma-memorize nyo as in, to better understand compensation, it is Article 1279. So, familiarize this. It will save you sa mga essay questions in your quizzes and exams, okay? So, Article 1279 enumerates the requirements or requisites of legal compensation. Absent any showing that all of these requisites are present, compensation may not take place. Walang legal compensation, okay? Absent any of these requirements. So, let's discuss one by one these requirements. First, ang sabi nga ni Article 1279, that each one of the obligors be bound principally, and that he be at the same time a principal creditor of the other. So, simply put, sabi lang naman talaga, the parties are principal debtors and creditors of each other. Example, ganito siya. Si Pogi owes Ganda 10,000 pesos. Tapos, eto namang si Ganda, may utang din siya kay Pogi na 10,000 pesos. So, compensation will take place because Pogi and Ganda are principal debtors and creditors of each other. Sila mismo yung principal debtors and creditors ng bawat isa. Okay? So, paano ba yung situation na hindi sila yung principal debtors and creditors of each other? Ganito, example. Pogi owes Ganda 10,000 pesos. Tapos guaranteed by, say, Beauty. Okay? So, si Beauty is yung guarantor ni Pogi. Tapos, si Ganda naman, in another transaction, may utang din siya kay Beauty na 10,000 pesos. So, dito sa example na to, there will be no compensation between Ganda and Beauty because although si Ganda is principally liable to Beauty kasi nga may utang din siyang 10,000 pesos kay Beauty, si Beauty is merely subsidiarily liable to Ganda. Wala naman talaga siyang utang kay Ganda. She is just a guarantor, di ba? Hindi siya yung principal debtor. Subsidiary lang yung liability niya dito. So, since they are not principal debtors and creditors of each other, so, yun nga, no compensation will apply. Yun yung ibig sabihin ng first requirements. So, proceed tayo sa second requirements. Sabi, dapat daw, both debts consist in a sum of money or of a consumable things of the same kind and quality. Pag consumable things daw, dapat same kind and quality. Okay, example ganito. Si Pogi, he obliged himself to deliver to Ganda 10 sacks of rice. On the other hand, eto namang si Ganda, meron din siyang obligasyon kay Pogi to deliver a 10 sacks of corn. Dito, walang compensation dahil yung obligasyon ng dalawa are consumable things, pero not of the same kind and quality. Di ba nga, kay Pogi is to deliver 10 sacks of rice, tapos yung kay Ganda, 10 sacks of corn. Diba? So, compensation will not takes place kasi nga things due are not of the same kind. Now, hindi rin naman pwede kahit pa rice yung obligation nilang dalawa if may specific variety ng rice at iba yung specific variety na gustong i-deliver ni Pogi at ni Ganda. Unless, yung isa is, halimbawa kay Pogi is ganito specific variety talaga ng rice, tapos kay Ganda is any variety, so yun, pwede. But that is another example of facultative compensation. Okay? Let's move on to the third requirements or the requisites. Sabi, yung debts daw ay dapat due. Both debts must also be due at the same time. So, due means that yung period has already arrived or yung condition has been fulfilled. Okay? Nagawa or nangyari na yung condition. Now, when you say demandable, it is in the sense or to the fact na wala sa debts has prescribed or walang obligation dyan na invalid or illegal. So, both are valid and at the same time, pwede talaga siyang ma-demand. I mean, demandable nga kasi yung condition ay nangyari na if ever conditional or kung hindi man conditional is kung sinabi mong due and demandable on October 1, dumating na yung October 1. Tapos, yun na nga, at valid yung debts na yon. So, example, Pogi owes Ganda 1 million, payable on December 25, 2020. Tapos, Ganda owes Pogi 1 million pesos, payable on December 30, 2020 naman. So, can there be legal compensation on December 25, 2020? Hindi pa, okay? Wala pang compensation kasi one of the debt is not yet due. Kasi sa December 30 pa, magiging due and demandable yung utang ni Ganda kay Pogi. So, hindi pa magkakaroon ng legal compensation. Pero, pwede nang magkaroon ng voluntary compensation if napagkasunduan nilang dalawa, di ba? Why not? But by operation of law, wala pa kasi kulang ng isang requisites. And that requisite is yung dapat yung both debts must be due. Now, proceed tayo sa next requisites. Ang sabi, dapat daw yung debts din ay liquidated. Pag sinabi mong liquidated, meaning yung amount is known or kahit hindi mo pa alam but can already be determined by simple computation. Alam mo na kung magkano, although kahit pa kailangan pa ng simple mga arithmetical process na lang, pero wala nang iba pang kailangan gawin, okay? Pwede na yon, that is already liquidated. So, example, Pogi owes Ganda 10,000 pesos. Tapos, etong si Ganda owes Pogi, yung utang niya kay Pogi, may babayaran siyang kay Pogi na share ni Pogi sa kanilang business. Upon which, yung amount nung kung magkano man yun ay hindi pa ma-ascertained. So, meaning, hindi pa liquidated kung magkano ba ang share ni Pogi sa business nila. So, obviously, compensation will not take place as the debt of Ganda to Pogi is not yet liquidated. If part of the debt of Ganda has been liquidated, compensation takes place with respect to that part without waiting for the liquidation of the rest or of the entire obligation. Now, proceed tayo sa last requisites. Sabi, neither of them or there be any retention or controversy commenced by third person and communicated in due time to the debtor. So, no retention or controversy has been commenced by a third person. So, this is the negative requisites for legal compensation. Anyway, ganito yung example. Dapat daw kasi walang retention or controversy na na-file yung third person. Example, Pogi owes Ganda 1 million pesos. Tapos si Ganda, may utang din siya kay Pogi na 1 million pesos. Pero, si Ganda ay may utang din kay Beauty na 1 million pesos. And so, yung credit has been garnished by Beauty. who claims to be an unpaid creditor. Okay? Meron pala si Beauty or nag-file pala si Beauty ng garnishment proceedings against doon sa credit ni Ganda kay Pogi. So, in this case, sa credit ni Pogi kasi may utang din si Ganda kay Pogi na 1 million pesos. So, in this case, compensation cannot take place. Kasi, compensation cannot take place between Pogi and Ganda dahil merong controversy which is commenced by Beauty. Nag-file siya ng garnishment proceedings. So, in the meantime, yung compensation is suspended. Okay? Now, if Beauty wins, then there is no compensation. But if Beauty loses the case, natalo siya dun sa case, then meaning compensation shall be deemed to have been taken or have taken place as of the date the requisites for legal compensation concurred. Okay? Magkakaroon ng legal compensation. So, that's it. Yun yung 5 requisites na kailangan yung tandaan palagi in dealing with compensation problems pag naharap kayo sa mga ganitong problema. Now, let's proceed to Article 1280. Notwithstanding the provisions of the preceding article, the guarantor may set up compensation as regards what the creditor may owe the principal debtor. So, obviously, ang sinasabi nito is compensation benefits the guarantor, di ba? Although the guarantor is only subsidiarily, he is not principally bound, he is given the right to set up compensation. Yung reason dito is that yung extinguishment naman ng principal obligation as a consequence carries with it the accessory obligation as a guarantee. So, si guarantor is given the right to set up compensation if ever. Example, Pogi owes Ganda 1 million pesos and Beauty is the guarantor of Pogi. Tapos, Ganda in another transaction also owes Pogi 300,000 pesos. Nung naningil na si Ganda kay Pogi ng 1 million 1 million pesos, si Pogi hindi siya makabayad. And so, as a guarantor ni Pogi, the question is, how much will Beauty be liable? So, in this example, si Beauty will be liable for 700,000 pesos only dahil pwede nyo namang i-set up yung 300,000 pesos na credit ni Pogi as the basis for partial compensation. Kasi di ba may utang si Ganda kay Pogi na 300,000 pesos. So, pwedeng i-set up yun ni Beauty. Okay? That is Article 1280. Now, Article 1281. Compensation may be total or partial. When the two debts are of the same amount, there is a total compensation. So, simple and very self-explanatory provisions. Total compensation results when yung dalawang utang are of the same amount, so they compensate each other, totally extinguish yung obligation. Pero if hindi sila the same amount, then they are of different amounts nga. So, compensation is total as to dun sa mas maliit na amount o na utang and partial only with respect to that larger debt. Diba? So, yun lang. Yun lang sinasabi ng Article 1281. Huwag na tayo magtagal sa kanya. Anyway, Article 1282. The parties may agree upon the compensation of debts which are not yet due. So, this is now voluntary compensation. It is an exception to the general rule that only debts which are due undemandable can be compensated. Actually, nasabi ko na siya kanina na pwede naman pero voluntary na sa parties. So, yung requisites na na-mention ni Article 1279, hindi siya mag-a-apply dito kay voluntary compensation. Kasi ito na kind na compensation has no special requisites. Dito, it is sufficient na yung agreement or yung contract mismo ng dalawang parties, which yung contract mismo na nag-declare ng compensation should be valid or should itself be valid. So, hindi necessary na mag-comply doon sa requirements ni Article 1279. Yun yung voluntary compensation. And kung gusto nyo ng example, actually yung sinabi ko kanina, dun sa hindi pa due and demandable, pero parties agree or yes, the party agrees for a compensation. Pwede naman. Okay? Now, Article 1283. If one of the parties to a suit over an obligation has a claim for damages against the other, the former may set it off by proving his right to said damages and the amount thereof. So, eto naman yung judicial compensation or set off. So, compensation may also take place when so declared by a final judgment of a court. Okay? So, ang sabi lang naman ni Article 1283, a party may set off his claim for damages against his obligation to the other party by proving his right to the said damages and the amount thereof. So, dito, all the requisites under Article 1279 must also be present. Except that, yung exception lang ay na yung time ng pleading, yung claim mo is not yet liquidated. Kasi, yung liquidation or yung pagdidetermine ng amount must be made in that proceedings. Okay? That is judicial compensation. Madali lang siya. Through court, ano kasi? I mean, it is declared by a final judgment of a, dahil sa court proceedings. So, Article 1284. When one or both debts are rescissible or voidable, they may be compensated against each other before they are judicially rescinded or avoided. So, compensation of rescissible or voidable debts. Well, basta tandaan nyo lang, rescissible or voidable debts naman, same with rescissible or voidable contracts, they are valid until annulled. Valid sila until rescinded or voided. Hence, dahil valid naman sila until voided, compensation is allowed. Kasi at that time, valid pa naman yung status nila. Pero to avoid unfairness naman, if ever yung rescission or annulment was later on decreed by the court after ng compensation, tapos na-declare na void yung debts or rescissible, yun nga, na-void or na rescinded yung debts na yon, then it is as if no compensation ever took place. Meaning, yung decree acts retroactively. Magre-retroact siya na to the point na like as if wala talagang nangyari compensation and so magiging liable pa rin yung debtor. Okay? Eto. Example. Si Ganda owes, Pogi owes Ganda 1 million pesos. Tapos subsequently, si Pogi through fraud was able to make Ganda sign a promissory note that si Ganda ay may utang sa kanya na 1 million pesos. So, through fraud, napasign niya si Ganda ng promissory note in favor sa kanya, kay Pogi. So, in this case, yung utang ni Pogi kay Ganda is valid naman. Pero yung utang ni Ganda to Pogi actually is voidable. Kasi nagkinuha yung consent niya through fraud. Diba? So, before the death of Ganda is nullified, okay, bago pa man na annulled yung utang ni Ganda kay Pogi, meaning valid pa. Valid pa yung utang. Both utang is valid, although kayong utang ni Ganda to Pogi is voidable, pwedeng i-nullify. So, since ang standing naman nila is valid, then both debts may be compensated against each other. If all the requisites or other requisites naman for legal compensation are present. Now, if supposed later on, si Ganda ay nag-file ng case to nullify yung utang niya kay Pogi, and later on, the court has annulled yung debts na yun ni Ganda, the court decided in favor of Ganda, so Pogi would still be liable, considering that The effect of annulment is retroactive. So, it is the same as if there had been no compensation. So, hindi talaga nag-compensate, hindi na-extinguish yung utang ni Pogi at ni Ganda. Okay? So, ngayon, si Pogi ay may utang pa rin kay Ganda na 1 million pesos. Okay, proceed tayo kay Article 1285. Ito yung medyo, mabigat. Anyway, mabigat i-discuss kasi mahaba yung provisions. Anyway, Article 1285. The debtor who has consented to the assignment of the rights made by a creditor in favor of a third person cannot set up against the assignee the compensation which would pertain to him against the assigner, unless the assigner was notified by the debtor at the time he gave his consent that he reserved his right to the compensation. If the creditor communicated the cession to him but the debtor did not consent thereto, the latter may set up the compensation of debts previous to the cession, but not of subsequent ones. If the assignment is made without the knowledge of the debtor, he may set up the compensation of all credits prior to the same and also later ones until he had knowledge of the assignment. So, okay, obviously, this provision talks about the effect of assignment on compensation of debts. So, okay, discuss muna natin yung scenario. Ganito kasi siya. Under the law, pag lahat ng requisites for legal compensation are present, compensation takes effect by operation of law. And so, both debts are extinguished to the concurrent amount kung magkano. Kahit pa nga si debtor and creditors are not aware of the compensation, automatic yun by operation of law. Hence, compensation actually takes place automatically. Okay? The parties in their own right becomes the debtor and creditor of each other, and lahat ng requisites under Article 1279 present lahat, so compensation takes place. Pag ganon. Now, isipin nyo, after ma-extinguish ang obligation through compensation, one of the extinguished debts, extinguished na sana, inassign pa to a stranger. Ordinarily, that is already useless act, di ba? Wala nang silbi. Kasi nga, there is nothing more to assign. Kasi the defense of compensation could actually be set up. However, there is an exception to the said rule. When the assignment, even after compensation has already taken place, was made with the consent of the debtor. Meaning, such consent operates as a waiver of the rights to compensation. So, dito, the defense of compensation could not be set up. Now, this rule is also not absolute. Meron ding exception to the exception. And that is when at the time he gave his consent, at the time the debtor gave his consent, he reserved his right to the compensation. So, that is Article 1285, Paragraph 1. Okay? Di nga ba sabi, the debtor who has consented to the assignment of rights made by a creditor in favor of a third person cannot set up against the assignee the compensation which would pertain to him against the assigner, unless the assigner was notified by the debtor at the time he gave his consent that he reserved his right to the compensation. Anyway, Article 1285, this provision actually covers three cases or three scenarios or situations. Meron siyang tatlong scenarios. First, yung nasa first paragraph, yun na yung diniscuss natin kanina. Tapos yung sa second paragraph, if the assignment was made with the knowledge but without the consent or against the will of the debtor. Tapos yung sa third, yung assignment is made without the knowledge of the debtor. Okay? Yung first, with the consent na debtor. Second, walang consent pero may knowledge. And alam niya yung ginawang assignment. Okay? Tapos yung third, wala talaga siyang alam. Wala siyang knowledge as to the assignment. So, ano nga ba ang epekto ng each situations or case? Again, let me repeat yung sa first paragraph. Bilisan lang natin. Compensation cannot be set up dahil meron ngang consent and so therefore a waiver of the compensation. Okay? Hindi masiset up si compensation kasi it seems like may waiver kay debtor. In the part of the debtor, yun sa compensation dahil may consent siya sa assignment. And exception to the exception is if the right to the compensation is reserved kung although may consent sa assignment, pero gumawa naman ng reservation to his right si debtor in case may compensation. So, yun yung exceptions to the exception. Now, let's take an example. Pogi owes Ganda 1 million pesos due yesterday, halimbawa. Tapos, etong si Ganda, meron din siyang utang kay Pogi na 300,000 pesos which falls due also yesterday. Kumbaga, yung debts is pareho ng due and demandable. Now, suppose lahat ng requisites for legal compensation are present. So, both debts are extinguished automatically up to the amount of 300,000 pesos since hindi pareho yung amount. Hence, ang utang na lang ni Pogi kay Ganda is supposedly 700,000 na lang as of today. However, if later on, itong si Ganda, he assigns his credit to Beauty, supposedly, diba, dapat Beauty can collect only the 700,000 pesos na lang. Kasi nag-set off na or nag-compensate na from Pogi. However, if yung assignment ng credit na ginawa ni Ganda in favor of Beauty is with the consent of Pogi. So, eto yung question. How much can Beauty collect from Pogi? So, since my consent ni Pogi, Beauty can collect from him the whole amount of 1 million pesos. Hindi niya pwedeng iset up ang defense ng compensation doon sa amount na 300,000 pesos dahil nga nagbigay siya ng consent doon sa assignment. Okay? Nagbigay siya ng consent without any reservation. Pero, if dun sa consent ni Pogi, he reserved his right to the compensation, then he could only be forced to give the 700,000 pesos na lang din sana. Kasi, may reservation as to the compensation. Okay? Malinaw ba? Anyway, take note din pala, if Pogi gave his consent to the assignment before it was made or subsequently, pareho lang under Article 1285, first paragraph. Pogi still loses the right to set up the defense of compensation. But he can still collect. Baka naman, di ba, lugi siya. Kasi nagbayad pa rin siya ng 1 million pesos. Pero, yung 300,000 na utang ni Ganda, pwede niya pa rin naman yung singilin kay Ganda. Yun nga lang, sisingilin niya na. Supposedly, kasi na-compensate na hindi niya na siya maniningil. Diba? Kasi, kumbaga, kinompensate na nga niya yung bayad dun sa utang niya na 1 million pesos. So, dahil nag-consent siya din sa assignment, nagbayad pa rin siya ng buo ng 1 million pesos kay Beauty. And so, yung remedy niya sa 300,000 pesos na utang ni Ganda sa kanya is to demand from Ganda or to collect from Ganda. So, in other words, the compensation shall be deemed to have not taken place. Parang wala talagang nangyaring compensation. Okay? Mas malinaw na ba? Anyway, I think so. Let's proceed to second paragraph, yung sa second situation. Ito yung assignment with the knowledge but without the consent or against the will of the debtor. So, dito naman, compensation can be set up regarding debts previous to the assignment, okay? Yung debts maturing or nagmature na before pa yung assignment. So, before pa yung notice or yung knowledge ng assignment. Now, example, si Pogi, may utang siya kay Ganda na 1 million pesos due on December 1. Tapos, si Ganda naman ay may utang sa kanya na 1,500,000 pesos and it is due on December 5. And then, in another transaction, Pogi owes Ganda 500,000 pesos ulit due on December 15. Okay? So, eto yung nangyari. Pogi assigned his right to Beauty on December 10. Okay? Pogi notified Ganda. Pinaalam niya si Ganda, but Ganda did not gave her consent to the assignment. So, yung question, how much can Beauty collect from Ganda? So, Ganda can set up the compensation of debts yung mga previous lang, di ba? He can set up yung as a rule, yung sinabi ko kanina, compensation can be set up regarding debts previous to the assignment lang. Hence, si Ganda can raise the defense of compensation with respect dun sa December 5 or with December 5 na debts which was before the assignment na nangyari noong December 10. Now, dun sa previously nag-matured nga na utang. Hence, Beauty can collect only 500,000 pesos kasi nagkaroon na ng compensation with respect to the 1 million pesos na debts noong December 5. But, Ganda cannot raise the defense of compensation with respect to the debt of Pogi doon naman sa December 15 kasi yon after na, di ba? Yun is nag-mature siya after na nung assignment. Okay, when the law says debts previous to the session, actually it refers to the debts na nag-mature before yung assignment or yung session. Yun lang yung pwedeng i-set up na as for compensation ng debtor. Okay? Now, yung third scenario, eto. Eto naman is pag yung assignment was actually wala talagang knowledge ni debtor. Diba? Yung second scenario is may knowledge pero walang consent. Eto, wala talagang knowledge. So, pag ganito daw, the debtor can set up compensation as a defense for all the debts maturing prior to his knowledge of the assignment. So, whether the debts matured before or after the assignment, hindi siya factor. Yung crucial time dito is yung time of knowledge of the assignment, hindi yung time of assignment itself. Okay? So, example. Gamitin pa rin natin yung same example nung second scenario. So, let us suppose that nung December 10, yung assignment that was made noong December 10, it was made without the knowledge of Ganda. And nalaman lang ni Ganda yung assignment only on December 25. So, in this case, kasi nga, ang crucial time is yung knowledge about the assignment. At ang sabi is, the debtor can set up compensation as a defense for all the debts maturing prior to his knowledge of the assignment. And since dito, December 25, panalaman ni Ganda yung assignment, dun pa lang siya nagkaroon ng knowledge sa assignment at lahat ng obligations, if you can see, ay nag-matured na. So, in this case, Ganda can set up compensation of credits sa lahat. Sa lahat ng credits either before and after the assignment, pati yung December 15. Kasi yung knowledge ay, nagkaroon lang siya ng knowledge about the assignment by December 25. So, that's it. That's Article 1285. Yay! Proceed na tayo kay Article 1286. Compensation takes place by operation of law, even though the debts may be payable at different places, but there shall be an indemnity for expenses of exchange or transportation to the place of payment. So this article applies to legal compensation actually. Indemnity for expenses of transportation. It applies dun sa transportation ng goods or ng object. Tapos, pag sinabi mong indemnity for expenses of exchange, ito naman is yung sa expenses for monetary exchange, like if the debts are money or yon. And ganito, example, Pogi owes Ganda $1,000 payable in New York. Tapos, si Ganda, may utang siya kay Pogi na 100,000 pesos in an equivalent amount payable in Manila. So, if Pogi claims compensation, then dapat siya yung magbayad for the expense of exchange. Okay? Expenses dun sa pag-exchange ng pera. Ang ibig lang sabihin talaga, whoever claims compensation, siya yung magbabayad for the exchange rate of currency or for the transportation. Kasi kung babasahin mo yung 1286, sabi lang naman niya, compensation takes place by operation of law. Alam na natin yun. And then, kahit pa daw yung debts may be payable at different places. So, kahit pa iba't iba yung lugar, and then, there shall be indemnity nga lang for expenses of exchange. Ito yung sa mga currency, tapos yung sa transportation to the place of payment. So that's it. That's Article 1286. Now, let's go to Article 1287. Compensation shall not be proper when one of the debts arises from a depositum or from the obligations of a depositary or of a bailee in commodatum. So, neither can compensation be set up against a creditor who has a claim for support due by gratuitous title without prejudice to the provisions of paragraph 2 of Article 301. Well, itong provisions na to, it talks about instances or situations when legal compensation cannot take place. So, let's tackle this, yung mga scenarios kung saan walang legal compensation. First nga daw is, yung nasa under first paragraph, sabi, when one debt arises from a depositum. So, please note, do not be confused ha. Hindi ito yung bank deposit. Iba yung legal term sa bank deposit. That is actually governed by a contract of loan. Yung bank deposit. It is not depositum as defined in this article. Depositum or contract of deposit is yung nag-deposit ka ng isang bagay to another and yung purpose is for safely keeping it and returning the same. So, ayun. For safekeeping, tapos i-return din. Okay? So, well, ang sabi ng Article 1287, compensation shall not be proper in this case. Okay? Naiintindihan ba? Example, Pogi deposited with Ganda 100 sacks of rice valued at, let's say, 100,000 pesos din. Tapos, si Pogi ay may utang din kay Ganda ni 1 million pesos. So, nung wini-withdraw na ni Pogi ang kanyang 100 sacks of rice from Ganda, Ganda refuses to deliver. Ayaw niyang ibigay. And she is actually claiming compensation. Kasi nga may utang naman sa kanya si Pogi na 1 million pesos. So, question, is Ganda allowed to compensate? Obviously, no, because this is an obligation arising from deposit or depositum. At ang sabi ni Article 1287, compensation shall not be proper pag ganito. Okay? Now, another example. Pogi deposited with his bank. Halimbawa, ABC Bank, nag-deposit siya ng 100,000 pesos. Pero may utang din siya. Later on, nagkautang siya sa ABC Bank ng 10,000 pesos. So, question, can the bank set up compensation? Yes, the answer is yes. Deposit in bank are actually governed by a contract of loan. Sabi ko nga kanina, hindi yan contract of deposit. So, don't be confused with the term. Yung depositor in a contract of dito sa bank deposit is actually the creditor, di ba? And yung bank is actually the debtor. So the bank therefore can set up compensation. Okay? Another instance when the legal compensation is not allowed by law. Sabi ni Article 1287, pag daw yung isa sa debts is or arises from comodatum. Okay, i-define na rin natin si comodatum. Si comodatum is actually a gratuitous contract kung saan yung isang parties delivers to another something not consumable so that the latter may use the same for a certain time and then return it. So, halimbawa is ganito. Ganda borrowed the car of Pogi. And if let's say si Pogi pala ay may utang kay Ganda na 1 million pesos, later on, hindi pwedeng sabihin ni Ganda na hindi niya isusoli ang car ni Pogi on the ground of compensation kasi nga may utang din sa kanya si Pogi na 1 million pesos. Kasi malinaw kay Article 1287, sabi niya, no compensation can take place when one of the debts arises from a comodatum. So, yun. That's it. Now, the purpose of the law is actually to prevent a breach of trust and confidence on the part of the borrower. Kasi, same way din dun sa depository and dun sa depositum. So, let's proceed to the third scenario, where one of the debts arises from a claim for support due by the titular's title. So, claim for support. Example, Papa is the father of baby, okay, a minor. Tapos, under the law, si baby is entitled pa ng support from Papa and so, sinusuportahan siya ni Papa. Now, later on, nagkaroon ng utang si baby kay Papa worth, halimbawa, 50,000 pesos. So, dahil yun naman ay utang, support cannot be compensated. Hindi pwedeng sabihin ni Papa kay baby na, in as much as you owe me 50,000 pesos, I will not pay your allowance or yours or whatever na support na ibinibigay ko sa'yo for 1 year. So, hindi pwedeng ganon. And that is very clear sa kay Article 1287, di ba? So, that's it. That's Article 1287. Now, halos karugtong lang din naman niya si Article 1288. Same concept na ano pa rin, yung mga instances kung saan walang legal compensation. So, proceed na tayo kay Article 1288. Sabi, neither shall there be compensation if one of the debts consists in civil liability arising from a penal offense. Ito yung pang-apat na scenario. Pag one of the debts daw is consists in civil liability arising from a penal offense, hindi rin siya pwedeng makompensate. Wala ring legal compensation in this situation, okay? It is simple as saying there is no compensation if one debt arises from a crime kasi civil liability arising from a penal offense. So ganun lang siya. Simple as saying there is no compensation if one debt arises from a crime. Example, ganito. Pogi owes Ganda 10,000 pesos. Tapos later on, nag-away si Pogi at saka si Ganda. And sa away nila, dahil magaling naman talaga si Ganda, she has inflicted physical injuries against Pogi. And dahil dyan, si Pogi nag-file ng case against Ganda. And so later on, the court rendered judgment in favor of Pogi against Ganda. The court ordered Ganda to pay Pogi 10,000 pesos daw, applying the principle na, alam niyo na, a person criminally liable is also civilly liable. Basta bottom line, the court ordered Ganda to pay Pogi 10,000 pesos. So, dito, hindi pwedeng sabihin ni Ganda na mag-set up na lang siya ng compensation kasi may utang din naman sa kanya si Pogi na 10,000 pesos. Ganda must pay the 10,000 pesos. Kahit pa may utang si Pogi sa kanya. Ibang usapan yon, maniningil siya doon. Okay? Sabi nga ni Article 1288, neither shall there be compensation if one of the debts consists in civil liability arising from a penal offense. Okay? So, civil obligation arising from criminal offense cannot be compensated. That's Article 1288. Now, wait lang din pala, wait. Although si Ganda cannot set up compensation, pero si offended party, si Pogi, dahil siya yung offended party in our example, he can actually set up compensation. He has the right of compensation. The prohibition in Article 1288 pertains only to the accused but not to the victim of the crime. Kung si Pogi mismo is gusto niya i-compensate na lang na wag mo na akong bayaran, Ganda, dahil may utang din naman ako sa'yo, so pwede yun. Okay? So let's proceed to Article 1289. If a person should have against him several debts which are susceptible of compensation, the rules on application of payment shall apply to the order of the compensation. So, dito nagbigay ng cross-reference to application of payment. So, yung rules on application of payments is also applicable sa compensation. Naalala niyo pa ba? Well, discuss na rin naman natin actually sa application of payment. Now, if gusto niyo ring ma-refresh, I'll put a link at the end of this lecture. Anyway, to simplify, ang sabi 'di ba, pag naalala niyo pa si application of payment, then mas madali niyo maiintindihan yung provision na to. Anyway, sabi lang naman or in essence is ganito siya. Pag sa debtor daw ay maraming debts which are susceptible of compensation. Okay, maraming debts and lahat yun pwedeng magkaroon ng legal compensation. So, siya is ang mamimili. He must inform the creditor sa alin doon sa mga debts na yon ang gagawin niyang object of compensation. And in case he fails to do so, pwede rin si creditor through the receipts, di ba? And if wala kay debtor, wala kay creditor, then, ano yung rules? The most onerous obligation. So, yung unang isi-set off or i-compensate is yung most onerous obligation. So, example, if Pogi is may utang kay Ganda in an amount of, say, 1,000 pesos without interest, tapos due na siya ngayon. Tapos yung isang utang niya is 1,000 pesos din. Tapos, may interest, say, 6%, and due na rin siya ngayon. So, if si Ganda rin ay may utang kay Pogi na 1,000 pesos and ngayon din yung due niya, then, walang nagbigay ng or nag-inform kung alin doon sa debts which are, di ba dalawang debts that are due, kung saan doon ang i-compensate sa utang ni Ganda. Ang sabi, the most onerous daw. So, yung dito sa example natin, yung second na utang, which is my 6% interest, yun yung i-compensate. So, ang maiiwan na utang na lang ni Pogi is yung 1,000 pesos na without interest. Okay? Yun yung ibig sabihin ni Article 1289. Now, Article 1290. When all the requisites mentioned in Article 1279 are present, compensation takes effect by operation of law and extinguishes both debts to the concurrent amount, even though the creditors and debtors are not aware of the compensation. So, well, madali na lang talaga siyang intindihin kasi kanina pa natin siya dinidiscuss. Yung sinasabi niya kanina pa, yung concept ng 1290, kanina pa natin na-discuss. Diba? Legal compensation takes place by operation of law. Okay? So, compensation occurs automatically by mere operation of law. From the moment that all the requisites mentioned in Article 1279, pag present na silang lahat, so legal compensation takes place. Kahit pa absence or kahit walang agreement between the parties and even if it is against their will, it extinguishes reciprocally both debt as soon as they exist simultaneously. Sabi nga, it extinguishes both debts to the concurrent amount. Now, yung concurrent amount, parang na-discuss na rin natin siya kanina. Anyway, pag sinabi mong concurrent amount, it means na yung isang debt is mas malaki kaysa sa isa. And so, meron siyang balance. And that balance will subsist. Maiiwan, matitira. Magiging nandun pa rin siya. magkakaroon pa rin ng obligation si debtor as to that remaining or subsisting balance. That's it. That's compensation. If medyo naguluhan pa kayo, I suggest balikan nyo na rin yung ibang discussion like yung sa application of payment, yung sa assignment, or kung sa confusion para at least mas malinaw. Thank you for watching and God bless.